The floor over to our presenters, Eric MacMichael, Nick Goldberg, and Nate Brown to talk us through this one. So over to you.
Great. Thanks, Amy. Appreciate it. And welcome everybody. Nice to see a lot of familiar names and Zoom displays. So we're going to be talking about, first of all, I'm Eric MacMichael. I'm joined by Nick Goldberg and Nate Brown. We're going to be talking about Keker's growing sports practice. Nate, we can go to the next slide. This is, as everyone knows, we don't have practice groups, but we've been really lucky to do a lot of interesting sports-related litigations over the last few years and have gotten to work in some interesting industries with some great people. And it's kind of a practice area more broadly that is just burgeoning right now because sports properties in general are increasing dramatically in value, and that is likely correlative to the value of sports media broadcast rights, which are also skyrocketing in value over the last several years. And I think what we're seeing in this area is that as the value of sports media broadcast rights increases dramatically, the contracts or legal relationships or other relationships that have historically existed to bundle and sell those rights are coming under a lot of tension and a lot of pressure, and that's leading to more and more litigation. So what we're going to do is talk through some of the cases that we've been fortunate enough to work on and talk a little bit about our sports practice. If we offend anyone's alma mater or if we offend any of your sports teams, we apologize in advance, but we're just going to try to do kind of a high-level overview of some of the cases that we've worked on. So the first one we're going to talk about involved the sort of the demise at that time of the Pac-12 as we all knew it. So as many people will know and recall fondly, the Pac-12 for many decades was one of the most prominent sports conferences in the United States. It had really an idyllic roster of universities, both from an academic but also from a sports standpoint, all geographically located close to one another, which really made for a lot of convenient and beneficial relationships between and among the schools. Starting in 2022, the Pac-12 came under enormous strain and enormous pressure to keep its conference together. And this was caused directly by the timing at which the Pac-12's new media contract was going to go out to market. So they were enjoying a 10-year media rights deal that began in the mid-2010s. It was expiring in August of 2024. And unfortunately for the Pac-12, a couple other conferences sort of beat them to market. The Big Ten got to market in 2022, and then the Big 12 sort of jumped in front of the Pac-12 in late 2022 and took their rights to market. And because of this increase in value, the new deals that they signed were significantly greater than the existing Pac-12 deal, and that put a lot of pressure on the conference to keep everybody together. And what we saw was first USC and UCLA announced in July of 2022 that they were going to join the Big Ten once the media rights deal expired in the summer of 24. And then that then, as we got closer to the Pac-12's renegotiation of their new deal, there was sort of a run on the bank, and 8 of the remaining 10 members fled in a span of about 48 hours in this sort of fateful period in late July, early August of 2023, leaving the conference with only 2 members. So as of that point in time, and we're going to sort of rewind the clock a bit as we go through this, but I just want to sort of get to the end first. As of that point in time in August of 2023, you had 2 members who were going to stay in the conference, and that was Oregon State and Washington State. The other 10 had all announced publicly that they were going to join competitor conferences in 13 months once the media rights deal officially expired. And so the question became, who's going to govern the conference over that remaining 13 months? Because the Pac-12 still had 1 year remaining on their media rights deal, which according to public reports was about $500 million of revenue coming into the conference. And the conference still had a significant number of assets, which it had acquired over its 100-year history. So the question became, who is going to be the decision makers for this organization as far as allocating that revenue, what to do with the assets? And you can kind of immediately see that there's a conflict here because 10 of the 12 are leaving to join competitors, and probably what's in their best interest is to, basically dissolve the conference and take as much from it as they can before they leave. And the other 2 want to regrow it and want to preserve it as a conference that they're going to remain part of. And that's kind of where we came in. So the dispute, and we can go to the next slide, really centered on what happens in this situation where a conference member has said, I'm going to leave, but that departure is not going to occur for some time in the future. And there were two very stark and competing interpretations of what happens in that case. What we argued, in citing to the bylaws, which I put up on the screen, is that once a member, quote, delivers a notice of withdrawal, then that member is automatically removed from the board of directors of the Pac-12 and can no longer participate or have any rights in the decision making. I've chosen to highlight the portions of the bylaws that really supported our position and sort of ignored and glossed over the middle part, which gets very muddled and creates a little bit of ambiguity, I would submit, in terms of exactly how is the situation supposed to be dealt with. But we can go to the next slide, Nate. The departing schools, the 10 departing schools, eventually arrived on the interpretation that delivering a notice of withdrawal really means actually withdraw. And they had a whole bunch of sort of logical and inferential arguments, as it wouldn't make any sense to punish people for simply saying that they were going to leave. And what the injury that the bylaws were really meant to protect was the actual withdrawal of members prior to the expiration of the media contract, because that would put the conference in breach and would give rise to a whole host of problems. So these were the two competing interpretations that were presented to the court about what to do with this conference for a 13 or 14-month period where everybody had to live together, even though 10 people were planning to get divorced from the conference in the not too distant future. And what we were able to do, we had sort of a very accelerated litigation that we'll talk about briefly, but it involved first getting a temporary restraining order, and then there was expedited discovery, and that led directly into a preliminary injunction hearing. And what we were able to establish was a very clear and consistent course of conduct by everybody in the conference, starting from the moment that USC and UCLA announced that they were going to leave, that announcement equated to a notice of withdrawal, and that in turn triggered the removal of those two schools from the board. So we were able, and Nate, we can go to the next slide. We were able to chronicle for the court all of the board meetings that took place after that initial announcement, in which those two schools, the chancellors or presidents of UCLA and USC, were not allowed to attend the board meetings, were not allowed to vote. They were recused from anything involving the direction or future of the conference. And the other 10 had implicitly or explicitly endorsed that interpretation by going along with a board comprised of 10 as opposed to 12. And so this was all of the evidence that we were able to get in discovery to show a course of conduct that was more consistent with our interpretation of the bylaws than the 10. And we can go to the next slide, Nate. And so again, and this was sort of a teeter-totter, kind of dynamic, where when it was USC and UCLA who announced that they were going to leave, and there were 10 remaining schools and 2 departing schools, then our interpretation was correct for the 10. But then as more and more schools started to find, homes elsewhere and started to announce their departure, suddenly the teeter-totter went the other direction. And now that interpretation was no longer palatable for them because it was 10 leaving and 2 staying. And so what you saw on this sort of fateful, 2 days in early August of 23 is, as more and more schools started to announce that they were leaving, they accompanied that announcement by saying, by the way, we are not issuing a notice of withdrawal, and we fully intend to remain on the board, and we fully intend to guide this conference moving forward. So we can go through these pretty quickly. So you had the University of Washington, you had Oregon, you had Colorado, and the other 5 schools who all left within a very short succession. Then finally, the 10 got together and said that they just simply could not accept the suggestion that Oregon State and Washington State would be the only 2 schools left in charge of this conference and all of its very significant assets. And our position was, basically, we don't care whether you can accept that suggestion or not. The bylaws mean what they say, and there's a consequence for their decision to leave the conference, and they shouldn't be allowed to make decisions, especially decisions that relate to dissolution or things that would fundamentally make it impossible for the conference to survive beyond their departure. And so that was essentially the question that was presented to the court on the preliminary injunction that we brought was who's more likely to prevail. I think we were able to convince the court that we were. And the question was, would we suffer irreparable harm if we had to wait until the end of the case to get the relief? And we were able to put together a pretty good record, we thought, showing that if the 10 were allowed to vote, that their intention was to, in fact, dissolve the conference, to sort of put it in mothballs initially, and then once they got closer to their ultimate departure, dissolve it and distribute all the assets to all the members, in which case there would be no conference left. And so the preliminary injunction that we were able to get in November of 2023, we can go to the next slide, Nate, recognized the argument that we were trying to make, which was that Oregon State and Washington State were the only two rightful members of the board of directors of the Pac-12, and they're the only two who should be allowed to decide all decisions on behalf of the conference, and that includes decisions about distributing revenue, just decisions about regrowing or recruiting, anything and everything that the board was entrusted with, which was essentially all material decisions of this conference. The court recognized that those decisions should be made by the two schools that are staying, not the 10 that are leaving. And then that preliminary injunction order paved the way for discussions at the end of 2023 and early last year, where the 12 schools were able to get together and fashion a resolution which has preserved the conference and allowed the Pac-12 to go on. And that's kind of a good segue into our next case, that we were able, sort of, as you know, one door closes, another door opens in life often. While we were trying to resolve that dispute, the two remaining schools in the Pac-12, Oregon State and Washington State, suddenly realized we need to schedule football games for the next year. So they knew that the 10 schools were going to be gone within a year, and football games are typically scheduled at least 18 months or 2 years out in advance. So they suddenly had a big hole in their dance card as far as football games. So the Oregon State and Washington State and the Pac-12 reached out to the Mountain West and entered into something called a scheduling agreement with that conference, by which both Oregon State and Washington State were able to schedule 6 football games each for one season. That was the most recent season in college football. And they paid a total of $14 million for those 12 football games. But keep in mind, at that time, the Pac-12 and its remaining members had virtually no leverage whatsoever because they were a conference of 2. And the Mountain West, I would submit, had significantly more leverage since they had what we needed. And they insisted on including a provision in the contract, which we have referred to as a poaching penalty provision. And it basically says that if any Mountain West member schools join the Pac-12 over the next several years, then the Pac-12 will owe very exorbitant and punitive liquidated damages to the Mountain West. And so it really serves as a strong deterrent for any Mountain West schools joining the Pac-12, not only for the year during which the scheduling agreement was operative, but for several years into the future. And this is essentially what it provides for in the contract, is this escalating range of penalties that the Pac-12 would have to pay if Mountain West member schools were to join the Pac-12. And that was sort of appended to the scheduling agreement at the insistence of the Mountain West, and something that the two schools really couldn't push back on at that time. And so lo and behold, what happens is, in this sort of ever-shifting landscape of college football, about 6 months ago, 5 members of the Mountain West announced their intention to join the Pac-12 once the current media rights deal for the Mountain West expires. Those schools are all listed here. They now want to become part of the next generation of the Pac-12. And immediately the Mountain West invoked this poaching penalty provision and is asking for millions and millions and millions of dollars from the Pac-12. And so what the Pac-12 has done, and we were lucky enough to be asked by them to represent them in this case, was file a complaint in the Northern District challenging the poaching penalty provision under the antitrust laws, essentially arguing that this is operating as an unlawful horizontal restraint on competition that is really making it economically infeasible for one and only one competitor to compete for Mountain West schools. And that would just so happen to be the one competitor that's the most logical for those schools because of the geographic nexus of the conference and the schools. We've also argued that the poaching penalty is just unrelated to the scheduling of football games. There's no reason why, if you schedule football games for 1 year, you shouldn't be allowed to compete for those members of that conference for years to come. This issue is currently being litigated, and it's just a really fascinating question of antitrust law, which the sports landscape is generating a lot of. And so that's a good segue to kick it over to Nick to talk about another really interesting antitrust case that we were able to do.
Thanks, Eric. Good to see so many familiar names. I'm Nick Goldberg. I have the pleasure of talking about the PGA Tour Live Golf saga, where our firm represented the PGA Tour in this litigation starting back in the summer of 2022. A little background on this case, which some of you may have read about or known about, but Live Golf is a breakaway tour. It's a tour that was recently founded in 2022. It is funded by the Public Investment Fund of Saudi Arabia. They have a ton of assets, obviously, some big financial backing there. And it was a long time coming. I mean, they were plotting their launch for a long time. And one of the things that they did that led up to this case was they had successfully lured away some of the PGA Tour's top players by signing them to these big guaranteed contracts. And when Live launched its first event in June of 2022, the PGA Tour responded to that. This was all before any litigation was filed, but the PGA Tour responded to that by enforcing regulations that the PGA Tour had in place that essentially limited PGA Tour members' ability to play in competing events. And obviously the Live Golf people knew that was coming. They had sophisticated lawyers, and they had long plotted to challenge the PGA Tour's regulations and imposition of that discipline as anti-competitive. And that's exactly what they did. But the fight was critical, because obviously if Live Golf was able to successfully enjoin the PGA Tour's regulations, the PGA Tour, of course, was concerned that that would spell the end potentially of a whole bunch of players playing together harmoniously on the PGA Tour, and a lot more defections to Live Golf. And so what happened, obviously, was Live Golf filed suit here in the Northern District of California, and they immediately moved for a TRO. And a group of players sought to enjoin these regulations, which I'm going to talk to you about in a minute. But it was before Judge Beth Freeman here in the Northern District of California, and she set just an extremely fast schedule for this very significant TRO hearing. The complaint was filed on a Wednesday, August 3rd. Judge Freeman ordered us to respond by the following Monday, and she held a hearing that following Tuesday. And we put together a big team here at Keker that included Eric. Elliot Peters argued. I was on it. A whole bunch of really, really incredible associates worked around the clock on our papers. And I'm going to walk you through sort of how this dispute played out. So obviously what you're seeing now is the tour. One of our key themes is that the tour is a unique league. It doesn't function like normal sports leagues. Can you go back to the last slide, Nate, just for a second while I talk through this? And the reason is that unlike the NBA or the NFL or Major League Baseball, the PGA Tour is actually a collective of members. And it's a membership organization. It's technically a 501c6 nonprofit organization. And this is critical because one of our key arguments is that the tour was governed by the members. And the way that it worked organizationally is that the members themselves had seats on the board. They agreed to the handbook where the regulations lived. They had a say in fact, adopting and approving the regulations. And so these were critical thematic arguments that we made. It was really the tour run by and for the players, the members. So here's the handbook on the next slide. As I mentioned, this handbook was publicly available. Everybody subscribed to it. All the members agreed to it. And the policy board that runs the tour included tour members. And so, we had arguments that these players knew exactly what they were agreeing to when they agreed to it, and there was nothing wrong or anti-competitive about the regulations that I am about to show you. So these are the two critical regulations that the Live Golf people and their lawyers targeted. But these regulations, when you actually think about it, are actually fundamental for the operation of the tour. And the way that the PGA Tour works is that the players all agree to assign their media rights to the PGA Tour. The PGA Tour then goes out, they bundle those media rights together, and they sell them to media partners. But the media partners want some assurance that if you have Jordan Spieth and Tiger Woods and Scottie Scheffler, and you've sold those media rights to NBC and told them that they're playing in PGA Tour events on the weekends that NBC is going to air the tournaments, that those same players aren't going to show up on some other network on the same day in some different golf tournament, because that would sort of eviscerate the value of the media deal that you've just done. So the way that the PGA Tour deals with that is they have rules. If you just go back to the last one, Nate, if they have rules that basically say you can't participate in non-PGA Tour golf events without a waiver from the PGA Tour, without some sort of exceptional circumstance. But critically, the PGA Tour members retain all of their other individual marketing rights, and they make money on their own sponsorships, wearing the little sponsorship tags of Nike or Ping or whoever on their shirts. They get all that value themselves, but in order to preserve the value of the tour, we, the tour, hold their media rights and want to make sure you're not participating in conflicting events. And that's what the next rule does. It actually sets out a set of circumstances which aren't ironclad. I mean, there are exceptions, but basically say as a general rule, you're not supposed to play in a conflicting tournament on the same weekend that a PGA Tour event is held without a waiver. But here are the circumstances in which we will give you a waiver. We'll give you a waiver if you're playing outside of North America, because the PGA Tour primarily plays events in North America. So if you want to play, up to 3 events in Europe, for example, and you've played, a minimum number of PGA Tour events, we'll generally grant you a waiver for that. If you're for example, an Asian-born player, you can play in your home circuit even without a waiver, in recognition that one of the goals of the tour is to grow the game internationally. But really what we care most about is the North American events, and Live Golf was hosting and continues to host a number of events in North America that just compete or on TV at the same times, or have events around the same times as these PGA Tour events. So if you go to the next slide, what is Live Golf? I mentioned this a little bit, but one of the key themes there, and one of the key arguments we had in opposing this temporary restraining order, is that setting aside the merits of these antitrust claims, where we felt like we had strong defenses, there was just no irreparable harm. There just was no irreparable injury. And that is obviously critical on a TRO, something that courts often look at first. And one of the arguments we had here was that Live Golf was doing just fine. They had access to a lot of capital. They had already launched. If you go to the next slide, Nate, they had signed, these are some of the key players they had signed to just these massive contracts that far surpassed really the lifetime earnings of these players in their entire history on the PGA Tour. These were publicly reported figures, and we obviously pressed hard in discovery for the actual contracts, but this is what was publicly reported. And as you see, 9-figure contracts for some of these key players. And one of the things that Judge Freeman immediately grasped is it just did not seem very credible that people like Phil Mickelson and Dustin Johnson and Bryson DeChambeau were in any way injured by their choice to take these big checks and play golf in a different venue on a different golf course and for a different golf league. So this next slide was one of the key slides that we used, I think, to great effect at the TRO hearing. We played this slide, and actually Judge Freeman asked us to play it again. It was quite honestly not a slide that our client loved to play, because it showed that Live Golf had already launched and made some inroads. But if you look on the left, in 2021, you see here a list of the top 10 players on the PGA Tour by order of what they call sort of performance impact. These are the players on the tour. The tour is a metric that sort of generates who are the most valuable players on the tour in the media, who's driving value based on their presence on the tour, and they rank them. And these were the top 10 in 2021. Well, let's take a look at the next slide. This is what happened when Live Golf launched. 5 of the top 10 now all of a sudden played for Live Golf. And so one of the key arguments that we made at the TRO stage was, look, we were dealing with a competitor. At that time, Live Golf had already launched. They were doing just fine in their early days, and so there was no harm to them. And what was the need for a preliminary injunction? In our view, there was none. So that was one of the key arguments. And then another argument we made, obviously, was about the nature of Live Golf's own contracts. So if you look at the next slide, this was a quote from Judge Freeman at the TRO hearing. Well, one of the things that we did from the very moment that we got the complaint in this case was Live Golf had filed like a 70 or 80-page complaint. It had hundreds and hundreds of pages of exhibits. And when they filed their TRO papers, they had declarations and thousands of pages of exhibits and expert reports. So that they had been very carefully planning this legal strategy for months. Well, one of the things that they did not include in any of these materials they filed with the court initially were their own contracts. And so we demanded on day one, we said, you have put your own contracts at issue, please produce them immediately. And I think they sort of found themselves in a catch-22, because if they didn't produce the contracts before the TRO hearing, of course, we were going to argue to the judge that itself was telling, that they don't want to show us the contracts, and clearly there's something in there they're trying to hide, and they shouldn't be entitled to this sort of equitable relief when they're doing that. And I think that they made a smart choice, but not one without risk, by giving us the contracts. But then that allowed us to point to provisions in the contract that were very restrictive. And their contracts indeed were, I believe, more restrictive than the regulations of the PGA Tour. I'll give you a couple examples. These are all public. But the Live contracts require the Live players to play in every single Live event, every single one, no exceptions. As you saw in the regulations I just showed you, the PGA Tour regulations have a bunch of exceptions. They have no releases for conflicting events. The Live players can't agree to any conflicting contract. That would include becoming members of the PGA Tour. They grant all of their media rights to Live, even if they had already granted their rights to the PGA Tour, which later became the basis for our tortious interference counterclaims. And, whereas the players on the PGA Tour retain the right to market themselves and gain sponsorships and earn the income from that, on the Live Golf Tour, the players had to wear Live Golf team apparel. And really our argument was that the Live contracts locked up the players worse than the PGA Tour contracts. And so how can you complain about ours when you're doing the same things and worse? And that was, I think, an argument that really resonated with Judge Freeman. Another critical point that we brought out in the next slide was that, in fact, the Live Golf people, the organizers of the tour and the players, had already, in fact, compensated the players for any alleged harm due to the PGA Tour's regulations. And the plaintiffs, the Live Golf players, had submitted this expert report by economist named Jeff Leitzinger. And in his, if you carefully read his expert report, he had, in fact, acknowledged that when Liv paid the players these giant guaranteed contracts, one of the pieces of consideration for those contracts was what he called the loss of expected lifetime earnings on the tour. So we then said, well, what irreparable harm? You're saying these regulations that you're challenging harmed you, but your own economist has said you, the players, have already been compensated for that harm by Live Golf. And again, I think that really resonated with the judge. So how did this all come out? Judge Freeman held, she unbelievably prepared in the way she conducted this hearing. I mean, the parties submitted thousands of pages of evidence and briefing and expert reports to her in like 5 days. And she came out in the hearing on Tuesday, having read everything. She was extremely well prepared. Both sides presented slide decks. I was just very impressed with the way she conducted that hearing. And she actually ruled at the hearing and denied the TRO, ruled in our client's favor, denied the TRO, and then later issued a written ruling. And these excerpts you see here are from the written ruling. But we sort of went across the board. I think that the irreparable harm argument is really, in the end, what sealed it for us. And the first holding there was that the plaintiffs had not shown that they'd been harmed. They just hadn't been harmed at all, let alone irreparably. And she pointed specifically to the contract, the guaranteed contracts they had signed with Liv that had already compensated them for the lost opportunity to play on the tour. That's directly related to the expert Jeff Leitzinger's report that I just showed you. And then when it came to actually looking at the merits of the Sherman Act claims, the antitrust claims, she sort of said, look, I don't think your showing at this stage is sufficient. I don't think you, the plaintiffs, have shown you're likely to succeed. And when we were at the hearing, I remember she said something to the effect of, when I read Liv Golf's briefing, I thought they made a compelling case, but then I read the PGA Tour's arguments and I thought, you know, there are some key weaknesses, and that's sort of in line with what she held in the written TRO order. But again, I really think that it was irreparable harm that moved the needle the most for us in winning the TRO. Well, that wasn't the end of the case. Obviously, a lot of this has been reported publicly, but the case went on. It just sort of changed. You know, what happened after this was the players, that Liv Golf had put the players out in front. I think they thought, probably correctly, that the players were the most sympathetic plaintiffs, particularly if you were going to seek injunctive relief on a TRO basis. Well, all the players saw the writing on the wall after they lost the TRO, and all of them, every single last one of them, dropped out of the case, particularly when we started to ask for their depositions. They all dropped out. And who did that leave? That left really one plaintiff, Liv Golf. They came into the case. We counterclaimed against Liv. They asked for an early trial date. We said, sure. We said, let's have an early trial date. We will do that. We want to get this case resolved. The thing that we need is discovery from the Public Investment Fund of Saudi Arabia, because they are a critical part of this. They were really not just the money, but the control behind everything that Liv Golf was doing. And that really put, I think, Liv Golf in a difficult position, because they wanted the trial date, but they also knew they were going to have to give up discovery from the Saudi Arabian Public Investment Fund to get it. And so their lawyer made a representation in open court saying, look, we're going to cooperate. We're going to cooperate with that discovery. We're not going to insist on formal service. By the way, I think formally serving third-party discovery in Saudi Arabia would have probably been difficult. They're not a member of the Hague. I don't believe we have a discovery treaty with them. It would have been quite difficult to get that formally. But they said, don't worry, we're not going to insist on any formal service. We'll figure out a way to do it, and then it'll all come together swimmingly. And this became sort of a critical part of this case going forward, and something that the judge heard about over and over, because in fact, those of you that have followed us will know that it did not go swimmingly. We had to fight tooth and nail to try to get any bit of discovery from the PIF. And in fact, we never got any. And I don't want to skip to the end, but that became critical. So what happened next is we tried to pursue this discovery, and the PIF claims sovereign immunity. They say we are a government actor as part of the Kingdom of Saudi Arabia. We have sovereign immunity under US law. We are a political subdivision of the kingdom, and they just flat out refused to comply with any discovery. No depositions, didn't produce a document, and they said sovereign immunity. So we litigated that. And critically, there is an exception in the Foreign Sovereign Immunities Act for commercial activity. And I wish I could say that I was the brainchild behind this litigation. I was not. This was litigated primarily by my partner, Brooke Dooley, and actually one of our fabulous associates, Miley Eats Rowe. They really took the laboring oar on this, and boy, did they do an excellent job. And they found a ton of evidence that the PIF was engaged in commercial activity in connection with LIV. I mean, it sounds simple, but it's really, really critical that you support it with evidence. And we had a lot of it, that in this context, the PIF was engaging in commercial activity with a direct effect in the United States by running LIV Golf. And this became our argument to try to defeat their sovereign immunity claim. And we did. We won it first with Magistrate Judge Van Keulen, if you look on the next slide, and then later affirmed by Judge Freeman when they appealed. But both judges realized that the evidence showed that the PIF was up to their eyeballs in everything that LIV has done. Yasir Al-Rumayyan is a government official that runs the PIF and chairs, the board that runs LIV, and clearly was involved in LIV. Judge Van Keulen called the PIF the moving force. And Judge Freeman basically said, look, you, the PIF, created this golf league. The golf league is in the United States. It clearly is trying to disrupt the tour operations. It has exclusive contracts. And so we're not going to exempt you from discovery in this US proceeding that LIV has chosen to bring. And that led to, again, no discovery from the PIF. Instead, what they did was they chose to pursue an interlocutory appeal to the Ninth Circuit. I don't think that appeal was going to prevail. I think we had strong arguments against it for the same reasons we won in the district court. But what it really did is it paved the way for a resolution of this entire case. And over the summer in 2023, in the next slide, you'll see that the case ended. And the way that it ended was with a dismissal with prejudice of all of LIV Golf's claims. It was reported at the time, really fundamentally misreported at the time, that there was going to be a merger or some sort of combination between the PGA Tour and LIV Golf. That was not what the then agreement was. The agreement was that the PGA Tour and LIV Golf would engage in discussions about a potential commercial transaction. By the way, those of you that follow golf will know that that transaction still has not occurred to this day. But what was binding as part of this agreement in the summer of 2023 is that the entire lawsuit went away for good with prejudice. So we were obviously very proud of that, and proud that we were able to defeat the TRO and end the case. So where do things stand today with the PGA Tour? The PGA Tour announced in December of 2023 that they were going to accept $3 billion of investment from a consortium of sports owners called SSG. This is a picture of Jay Monahan on the left shaking hands with John Henry, one of Eric's favorite people who owns the Boston Red Sox, on the right. SSG is backed in part by Fenway Sports Group, but other sports owners as well. So the PGA Tour has this $3 billion investment. One of the things they did, which is, to my knowledge, the first deal of its kind in major professional sports, is they gave a big chunk of that money, 1.5 billion, goes to equity of a new entity, which is called PGA Tour Enterprises, and the players that were loyal and stuck with the tour are now direct equity holders in that business, and those shares vest over time as they continue to play on the tour. And to my knowledge, it's the first time that players have direct ownership in essentially what is a league. And obviously, as this slide shows, there are still ongoing negotiations with the PIF, but no deal on that front. So the case has ended. The PGA Tour continues. Live Golf is still continued, and for better or worse, the golf landscape is in this state of a little bit of remaining division between the two sets of tours. So with that, I will turn it over to Nate Brown to talk about one of our other favorite sports clients, Major League Baseball, and baseball sports issues.
Hi, everyone, and good afternoon. It's fitting that we're doing this over Zoom because you can all see my background actually is a painting that hangs in the Phillips collection in DC of a night baseball game, the Yankees versus the Washington Senators from my hometown of DC. So I'm going to talk a little bit today about our baseball cases, some that we've litigated here at Keker, Van Nest, and Peters, some that we haven't. I am going to kind of touch on two themes here. First, I'm going to talk about trial lawyers as utility players, and then I'm going to take us back to perhaps your 1L torts class and talk a little bit about assumption of the risk and the baseball rule and foul balls and injuries. And so just taking a step back about this trial lawyers as utility players, there are 2 points that I want to stress today. One is that sports cases are often highly publicized, as you've seen from Eric and Nick's presentation. So it's really important to hire lawyers who understand how to litigate and operate in the public eye. You know, often lawyers are doing both the legal work in court and to an extent public relations work too. The second point that I want to touch on related to this theme is that sports teams and leagues are involved in a wide variety of lawsuits. You really can touch on anything, and I'll walk through some examples soon. But so it can be in their benefit to hire generalists who are excellent in many different areas of the law. So let's talk about some of the variety of cases involving baseball in particular. Antitrust is an issue that comes up in baseball all the time. These are all cases that we've worked on. So it comes up in many, Major League Baseball has an antitrust exemption, and that comes up in many different types of cases related to employment and franchise relocation. And we've worked on a number of those cases. Consumer class actions are a big type of case that sports teams and leagues deal with. Agenman versus Major League Baseball that you see here, that was a case involving ticket refunds for the shortened COVID season in 2020. And there were only about 60 games played instead of the normal 162 games in that season. So plaintiffs brought suit related to getting refunds for season tickets there. There's also defamation can come up in sports cases, perhaps more often than you might think. This case, Bubba Harkins was an Angels employee who was fired as part of the league's crackdown on pitchers' use of sticky substances that enhance pitchers' grip and increase spin. And so after he was fired, he brought a defamation case against Major League Baseball. And then the last case on here, premises liability, involved a San Francisco Giants outfielder named Mac Williamson, who filed suit over an injury that he sustained while tracking a ball in foul territory at Oracle Park. So, he suffered a concussion, and he claimed that that caused his career to go downhill. And we, of course, vigorously disputed that that was the cause of his career going downhill. And so you can see from this list that sports law isn't just one small area of law. It can really cover everything from a number of different topics that you learned about in law school. It can cover civil procedure, can be a big issue, antitrust, defamation, consumer class actions. All of that can come into play in these baseball cases. So next, I want to talk about assumption of risk and the baseball rule. So ever since, I think, 1913, well, ever since before that, people have been hit by baseballs, foul balls, hit into the stands. And I think the first case where someone brought a lawsuit related to this was in 1913. And that led to something called the baseball rule, which means that a team, a league, a ballpark has no tort liability for injuries suffered from balls that are hit into the stands outside of the netted zone. So if you've been to a baseball game, you know that there is a screen behind the plate and going a little bit up the first and third base lines. And what courts have routinely said about this is lack of a screen is as obvious as the fact that the Grand Canyon is a chasm, and the danger that a spectator hit by a foul ball may be injured is as evident as the likelihood that one who falls into the Grand Canyon may be hurt. So it's you could think of it in 1L torts language as having no duty, that the team has no duty to those fans that choose to sit outside of the screened area in a baseball stadium. So, this case, this is from 1935, and it says, when a fan chooses to occupy an unscreened seat, he or she voluntarily assumes the risk of being struck by thrown or batted balls from foul balls or errant bats, and defendants owe no duty. So this rule, as I said, has been in place for over 100 years. There have been some newer cases that add a little bit of nuance to it, though. This case, Sumner J. versus United States Baseball Federation from 2020. It adds a little bit of nuance, at least in cases where netting might be below the industry standard. So, as it was in this case. So, in this case, the court held that U.S. baseball had a duty to take reasonable measures that would increase safety and minimize those risks without altering the nature of the game. And that's a really important phrase right there, without altering the nature of the game. Of course, a baseball stadium, a team could encase the entire field in nets and make it so that no foul ball ever hit someone in the stands. But spectators, fans would likely revolt. There are a lot of fans that want to have that experience of having that clear view of the game, and it would fundamentally change the relationship between fans and they want to dive for those foul balls. That's a big part of the game. They want to interact with the players as they're racing to catch to run after a home run ball. They want to catch that home run ball. And so putting up nets everywhere, of course, would fundamentally, alter the nature of the game. So that's a huge kind of part of the analysis, at least for courts that follow this Summer J versus United States Baseball Federation rule. And so there are a number of other issues that come up in these foul ball cases that are worth talking about. Standing can be an issue. There was a case from a few years back called Payne versus MLB, where Major League Baseball was sued by individuals who had not been hit by foul balls, but they were afraid of being hit by foul balls. And so they sought injunctive relief. They wanted netting from foul pole all the way around to foul pole. Their case was dismissed in part because even their own expert, agreed that there was a 0.00 something chance that they would actually be hit by a foul ball. So they had no standing. Other issues that often come up can relate to claim waivers and agreements to arbitrate. Tickets that are sold nowadays often have these claim waivers or arbitration agreements. And so that can come into play in these cases as well. And then mascot violence. You would not necessarily expect this to be a big part of the legal landscape surrounding baseball, but it does come up occasionally. And so I want to take a couple minutes before we end here to talk about perhaps my favorite baseball case, which we were not involved in. Keker, Van Ness, and Peters were not involved in. But it involved the Rancho Cucamonga Quakes, a Class A minor league team. And it featured a mascot by the name of Tremor. And this is a picture of Tremor right here. You can see he's a 7-foot-tall dinosaur. And he has a giant tail that's partially concealed in this image here. But so what Tremor would do during games is he would walk around the stands and he would take his giant tail and he would bash people over the head with it. People who didn't necessarily expect it was coming, people who were just sitting there trying to enjoy the game. And so once in 1997, Tremor was, the court said, performing his antics in the stands just along the left field foul line. He was behind a fan and, like he always did, started beating him with his tail. And at that very moment, the plaintiff, was distracted and turned towards Tremor. And at the moment he was turning back, he got hit by a foul ball. So the question, of course, was, was there a duty to not, commit mascot violence in this context? And so the court held that defendants, the Class A minor league team, had a duty not to increase the inherent risks to which spectators at professional baseball games are regularly exposed and which they assume. So no summary judgment. There was a triable issue of fact remained, which was whether Tremor's, quote, cavorting in the stands and distracting plaintiff's attention while the game was in progress constituted negligence in the form of increasing the inherent risk to plaintiff of being struck by a foul ball. So if any of you teach 1L torts, I would submit that this is a great exam question to pose to your students. So with that, I am finished, and I think we have some time for any questions for me, for Nick, or for Eric. Thank you all very much.